So good morning. Good morning and welcome to our panel discussion today on decoding all of these judicial ethics committees. The first comment I want to make is I see a number of the participants this morning from the hike. And for those who didn't go, I want to certify that we've been doing this about 15 years. And I think we've only lost one or two people. Today, everyone came back. So I have the pleasure of serving as the vice chair of the Supreme Court Committee on Judicial Ethics Opinions. But, as I hope you know, we are just one of many of the groups in California that deal with judicial ethics. And over the last 3 or 4 years since I've been a member of this committee, when myself or my colleagues have gone out to speak to judicial groups, we've always returned with essentially the same comment. Nobody knows who we are, nobody knows what we do, and they're not quite sure where we fit in. And we get asked all kinds of questions and all kinds of inquiries at our office, like, can we file a complaint against a judge? Do you do oral advice? Are you the Supreme Court, the Judicial Council, or CJA? We're not really sure. So that's why we're here today, because we want to see if we can't resolve some of that confusion, if we can't explain to you what we do and how we do it and the procedures we follow. So with me today are the chairs of the other three organizations. Justice Ron Roby is the chair of the Supreme Court Committee that I sit on. He was unable to attend today. But we have with us today the chairs of the three other organizations. So we have Justice Rich Feibel, who's chair of the Supreme Court Committee, Supreme Court Advisory Committee on the Code of Judicial Ethics, Judge Tony Moore, who's the chair of CJA's Committee on Judicial Ethics, and we have Judge Erica Yu, who's chair of the Commission on Judicial Performance. What I want to start out by telling you, though, is we do have something all in common, and that's the canons. So each of us in some way play a role with regards to the canons. But it's different, it's distinct, and we have different procedures as to how we resolve our issues that come before us. So we have a pretty lofty goal. We want to make sure today that you walk out knowing the difference between each of us, what we do and how we do it, and that you have somewhat of a roadmap to guide you through these committees, because they are important. They provide a service not only to us as judges, but to the public, and that they can provide you extensive information that guides you through the dilemmas that each of us encounter as we do our day jobs. So we're each going to take a few minutes and tell you about our committee and how it works and what it does. Then we're going to do a little panel discussion to hopefully illuminate how we're different and how we interrelate. So we'll start with Justice Feibel.
Okay, thank you, Justice Miller. Welcome to everybody. Can you hear me okay? Good. I want to thank the CJA for inviting us here today. It's going to be a real pleasure. You know, I thought, how can I start this out? And so I thought, well, if you had a book cover, you know, you're reading a book and you go to the inside cover, what's a good way to look at this? And I think that sort of as an overview would be that, as I'll explain in more detail, under the California Constitution, the California Supreme Court is charged with making rules for judges' conduct on and off the bench, and that's in the canons in the Code of Judicial Ethics. Its advisory committee, that is the committee I'm chair of, which is the Supreme Court Advisory Committee on the Code of Judicial Ethics, does just what our name implies, which is we advise the Supreme Court. And so they can make decisions on what should be in the canons. The code, and I know some of you have a copy of it with you from earlier sessions, has advisory committee commentary in it. That's commentary written by the advisory committee to try to guide judges in reading the code and what these particular provisions mean. So the Supreme Court is the body that actually decides on these canons and any amendments to it. Our committee advises it. In terms of interpreting the canons and giving advice, there are two committees. There's the Supreme Court Committee on Judicial Ethics Opinions, and that Justice Miller is a part of, and he'll talk about that committee. And then there's, of course, the CJA Ethics Opinions Committee that Judge Moore would talk about. They interpret the canons and give advice to judges. And then in terms of the enforcement of the canons is the Commission on Judicial Performance, and Judge Yu will talk about that. So you basically you're kind of in civics class from making the law to interpreting the law to enforcing the law. So that's the big picture. California, since 1949, has had written standards of judicial conduct. It started with use of the model ABA code that was adopted by the predecessor association of the CJA. In 1995, the people of California passed Prop 190, then amended the California Constitution in Article 6, Section 18M, which provides essentially that the Supreme Court has the authority to make rules for the conduct of judges on and off the bench, and for the conduct of judicial candidates in judicial elections. And after that amendment was passed, the Supreme Court appointed an advisory committee back in 1996. It was chaired by Justice Vogel, and that committee basically went through the existing code, recommended a new code, which incorporated a lot of existing provisions from the ABA code and the CJA code, and that new code has been in effect since 1996. So that's what we're dealing with. Now, since 1996, the California Supreme Court has been in charge of the code and any amendments. So the sort of the takeaways from this are, number one, that the California Constitution gives the authority to make rules about judges' conduct to the Supreme Court, not to the Judicial Council or to any other body. That's a pretty big confusion among people in the world that Doug is talking about. It's the Supreme Court that makes the rules, not the Judicial Council. And the advisory committee advises the Supreme Court on possible amendments, and we are assisted. We have a huge staff, of one. So our staff is a superb lawyer whose name is Mark Jacobson, who works for now the Legal Services Office of the Judicial Council, and he not only helps us, but consults, as many presiding judges know, with presiding judges throughout the state. But he's been invaluable, and I've been on this committee since 2002 and the chair since 2004, and he is of great assistance to us. Now, the other big picture item here is that any amendments to the code are always considered with a broad perspective on the vision of the code and the core principles of the code, which are impartiality of the courts, which means the courts have integrity, independence, are free of bias and discrimination, and that any kind of a view of the conduct of judges on or off the bench or of judicial candidates is always viewed from the perspective of an impartial judiciary, and the constitutional interest the state of California has, very strong constitutional interest in having an independent and impartial judiciary. Even this week, in the Williams-Uli versus Florida Bar case decided by the United States Supreme Court, in Justice Roberts' lead opinion, Chief Justice Roberts' lead opinion, he starts out with citing Caperton and the compelling interest the state has in an impartial judiciary and the power of and authority of state Supreme Courts to make rules governing the conduct of judges. So the kind of logical questions are, where do these ideas come from for amendments, and what is your process? So I thought I would talk about those items first. Where do ideas come from? It's easier to give you a list of where they don't come from. I made a little list of where they, over the past few years, from the Supreme Court itself, many from individual judges, some of whom are in this room. From the CJA, we get a lot of input from the CJA, from the CJP, from the Judicial Council or Judicial Council subcommittees, We get them from members of our own advisory committee. We read opinions, both of the CJEO, the Judicial Ethics Opinions Committee of the Supreme Court, and of the CJA, and we look at those opinions for ideas. And then in situations like this week, where the Supreme Court of the United States issued an opinion on judicial conduct. For those of you not familiar with the case, it basically, the state of Florida made a rule in their canons that says judges cannot personally solicit campaign contributions. The rule is different in California, where, as you know, judges can personally solicit. But in Florida, the rule was it cannot. In a 5-4 decision, the Supreme Court upheld that rule and said that that was permissible because of the state's strong interest in an impartial judiciary and sort of the appearance of having judges asking for money, particularly from lawyers who had cases pending before that court. Years ago, when Republican Party versus White was issued, we amended the Supreme Court amended the code to modify the commitments and promises clause. We did not have the announce clause, but we did have something that said if you appear to commit to a position, that was a violation of the code. We thought that was too vague, and we recommended to the Supreme Court to change it, and they did. So what's the process? The process basically goes like this. At some point in time, the Supreme Court either asks our committee to look at a possible amendment, or our committee, based on all this input that I've discussed, recommends to the court that we take a look at a particular issue. So basically, we only react to a Supreme Court actually officially asking us to look at an issue, but it can come not only from the court, but it can come at our request. We analyze that issue. We then report in extensive writing and report to the court our analysis. We either say we don't recommend this amendment, here's why, or we say we do recommend an amendment and that public comment be solicited. And we then ask the court for permission to solicit public comment. And they generally agree with us, and we will solicit public comment. We lay out what the proposed change is, what the reasons are for the change. We give a pretty extended period, depending on what we think, how controversial the issue is, and we get the public comment. We then review all the comments and make another report to the court. We give the court another written report saying we think these public comments are worthy or unworthy, and here's why. We say, well, we think our original suggestion should remain the same or perhaps modify it. Many times public comments influence us to clarify a rule or to actually modify it. We give the court all the public comments, so the court has all the raw data that it needs to analyze this, and then the court votes and decides whether to amend the code. I thought it would be helpful just to, by way of example, to talk about a few of the changes over the last few years to give you a sense of what we do. I know in your material, you know there are 8 members of our committee, so you see the names. We didn't want to go through each one of them. There's a mix of trial judges, appellate judges, retired judges. David Rothman's on our committee, for example, and Beth Jay, who's just retired as principal attorney to the Chief Justice. So it's a pretty broad committee in terms of experience. Generally, as I've talked about, we get discrete issues, and we're asked to look at those. The big exception to that is in 2011, the court said to us, look, we've just had a Commission on Impartial Courts that issued a very big report. Some of the recommendations affected ethics for judges, and also the ABA amended its code of model judicial conduct, and the court asked us, look, take a look at the Commission on Impartial Courts report, the ABA model code amendments, and any other issues that have come to your attention, and you come up with what you think should be a comprehensive review of the code. We did that and made a very, we had public comment, analyzed it, and then effective January 1st, 2013, the California Code of Judicial Ethics was comprehensively amended based on changes in the ABA code as well as the Commission's report. Now, since that time, a couple things have happened. One is that we've received a lot of comments about, hey, you know, this is unclear, this is an unclear provision, this could be improved. So we recently sent out 13 possible amendments. They all amount to clarifications of things ranging from who's required to take the mandatory ethics course for judicial candidates to what does disclosure of campaign contributions mean when it says it's an open court. And there's an example where we took a CJEO opinion and incorporated that into the new rule. The other exception, of course, is the recommendation that there is, as you know, there's a rule in California that judges cannot be members of any organization that invidiously discriminates on the basis of a whole host of categories, including gender and race and sexual orientation. And there are 23 states in the United States that have a prohibition against judges being members of organizations that discriminate on the basis of sexual orientation. California was the only state to have an exception for nonprofit youth organizations. It's quite an anomaly for California to be the only state in the union to permit a judge to be a member of an organization that discriminates, but has an exception for nonprofit youth organizations. We